can relive these things with you. All right, here we go. Tax gross up or not to gross up? Back with the question, whether kids know what in the mind. Tax lawyer Rob Wood writes in a recent edition of the California Tax Lawyer, how and when we're paid, whether for service or for property, can influence the amount of tax we have to pay. And that seems so obvious that no one would need to say it, much less prove it. Nevertheless, in civil litigation, the extent to which you can get damages with adverse tax consequences has been a thorny subject in the past. My guest is tax lawyer Rob Wood. He is partner at Wood & Porter in San Francisco and host of the Tax Law Channel. Looking good, Rob. Welcome.
Thanks. Nice to be here, Scott.
You know, the concept of grossing up taxes, and I guess to make it simple, is that putting together a damage award and then considering what the tax implications are going to be and then adjusting the award so that it's sufficient is what we're talking about, right?
Yeah, that's right. And there's obviously a cause and effect relationship between settlements or judgments and taxes, but I think the point here is that we're not necessarily talking about how much tax the person pays. So just to take a simple example, the plaintiff has a dispute of virtually any kind with a defendant. A plaintiff wants $1 million. The case settles for $500,000, and then kind of everybody knows that one of the things you look at is, well, how is that $500,000 taxed, and what can the plaintiff do to minimize it? But here we're talking about before the case is resolved, is it possible for the plaintiff to raise the tax argument and say, you know what, if you're going to give me $500,000, here's how it may be taxed, and you really have to give me $700,000, otherwise I'm not settling. And so one of the things obviously we're looking at is the extent to which you can introduce evidence of taxes in civil cases and get a judge or a jury to actually award you extra damages.
And this would seem very applicable in certain cases of employment disputes or employment law, or in the case I think that you said in your article too, where a defendant has actually done something that causes the tax burden to be considerably higher for the plaintiff.
Yeah, that's right. And there you have to look at both sides of this. Obviously, defendants don't like this don't like this doctrine generally. They don't like the fact that the plaintiff may be maybe asking for additional damages. But interestingly, there are cases in which defendants are the ones raising the issue, saying, for example, look, to go back to my $500,000 example, look, we're going to pay the plaintiff $500,000, and in fact, the plaintiff is going to save taxes because of X, Y, and Z. Sometimes the defendant is aware of certain tax issues. For example, the plaintiff may have claimed certain deductions on a prior year return, and sometimes that comes out in discovery, and so sometimes it's the defendant saying it's not tax burden we should be considering to the plaintiff, but rather tax advantage, and that should, again, to go back to my numbers, that should mean we should only pay $400,000, not $500,000. So it's kind of a two-way street, or at least it can be.
Can you give us some examples in history and also maybe some wage and non-wage examples?
Sure, and I think, as you say, Scott, the employment arena is probably the most prevalent or most obvious context in which someone is going to be arguing, the plaintiff typically, arguing about taxes. So for example, someone who is fired, and in the Eshelman case, which I talk about in the article, someone who's fired and sues and then ultimately by settlement or judgment recovers a large amount that effectively is paying them for multiple years. generally speaking, under our tax system, there would be a higher tax burden on a lump sum payment like that as opposed to payments stretched out over time. So that's kind of an obvious one where the plaintiff often these days is saying that they should be getting something extra for the increased tax burden. And jurisdictions vary in how they consider this issue. It often is controlled by state law, and the state laws vary. Some states are quite willing to take this kind of tax evidence into account in awarding damages, and some are not. But I think that's an obvious one where very frequently these days the plaintiff does have some good arguments. I think the other ones, that is outside the employment arena, it is harder. And yet there are cases involving contract disputes, for example, where plaintiff and defendant are arguing. A plaintiff says, you defendant didn't deliver these goods, and that caused me to have to go out and cover to buy other goods, and I had to liquidate investments in order to do that. I experienced a loss on those investments, or I'm not able to use the tax loss. I mean, you'd be surprised how innovative people get in terms of arguments they make about consequences of a defendant's actions, and many of those consequences have a tax element to it.
And one way to solve at least some of the problems is structuring the award, and that's something that we talked about obviously at length here.
Yeah, no, absolutely. And I think the other critical point here, but you're right, structuring is often looked to as a way, appropriately looked to as a way to help mitigate the tax impact. But one thing here that's clear if you read the cases, and that is you need to think about this at the right time. And that's kind of an old saw for us, that you don't want, just as you don't want to wake up on April 15 and start thinking about taxes, you also don't want to have your case concluded and the jury considering it and then think of this tax issue. Obviously, in most cases, then it's too late, although I would say there have been some people who have done this in post-trial motions. So, I mean, the time to think about this, hopefully, is well in advance, either to give yourself some additional damage arguments. You might either use expert testimony or a damages study, saying with an accountant or a lawyer saying, here's the tax problem and it might add to your damages. That can help you in mediation or settlement discussions. And obviously, if a case is going to trial, you want to have this in advance so that you can present it to the judge in a motion in limine or otherwise, saying this is what we want to present.
My guest is Rod Wood. He is partner at Wood & Porter in San Francisco. He is a tax law expert. He is the host of the Tax Law Channel here on the Legal Broadcast Network. He's written over 30 books on tax law, and you can find his writings in places like the California Tax Lawyer, Tax Notes, and Forbes. Rob, as always, a great pleasure. Thanks for your time.
Thank you, Scott.
This is Scott Drake, and you're watching the Legal Broadcast Network. 8 minutes, that's absolute perfection.